value and how that might benefit Arturo or might benefit Ms. Ma. That's a great argument if there's a quantum merit claim being made. There is not. There is not a quantum merit claim being made here. So it doesn't really matter if it decreased the value or increased the value or by how much. It's an irrelevant argument. Counsel complains about documents produced or not produced. Well, if he had a problem with document production, the time to talk about that is not today. The time to talk about that is in a motion to compel here. He not only didn't do that, he argued against the continuance that Best-Tex filed. So I think that argument also is inapplicable. And whether someone knew or didn't know about concrete being poured or not poured, again, that does not deal with the law of agency. The law of agency is very clear, and there simply is no evidence in this case to show that there's actual or express authority of the owner to Arturo Hernandez or apparent authority. It's just not there, and I believe that we're entitled to judgment as a matter of law.
We did file a motion to compel, but we took it down when it was supplemented, Your Honor.
So there is or is not a pending claim for quantum merit?
There's no pending claim for quantum merit against Alice Ma or Hernandez, but against Faruska there was. The people that we had the contract with was Faruska.
Okay, does Best-Tex, Best-Tex, do you have a claim for quantum merit?
Yes, against Best-Tex. Well, and we're claiming that Faruska is individually liable on that because of the corporate privileges being forfeited. Okay. But yes, we do have a quantum merit claim against Best-Tex.
Okay, I'm going to wait and let you proceed. So defendant Best-Tex, you may call your next witness, but let me ask Ms. Pierce, how much time is remaining?
Plaintiff has 17 minutes remaining. Defendants have 34 minutes remaining.
Okay, thank you. You may proceed.
No rest, Your Honor.
Okay, defendant Best-Tex has rested. So you may proceed, Mr. Whitten.
We also rest.
Okay. All right. Mr. Whitten, do you have the Best-Tex case that you could email to the court and opposing counsel?
Yes, Your Honor.
All right. You may give a brief closing.
Thank you, Your Honor. May it please the court, the causes of action that we have are against Best-Tex Construction LLC and Roy Faruska, DBA Best-Tex Construction. Those causes of action are, at this time, we had a sworn account for the $27,279. It's undisputed because there was no verified denial of the account, and therefore it is taken as admitted. The verified denial from Mr. Faruska was that he was liable in the capacity sued, but as our exhibits show, the corporate privileges of Best-Tex Construction were forfeited in January of 2017 prior to the entry of the agreement between Mr. Faruska and Big D Concrete to deliver the concrete to the address in McKinney where it was used to pour the slab, Your Honor. Since the evidence shows that Mr. Faruska was the managing member, then the forfeiture of those corporate privileges makes him individually liable under 171.255 of the Texas Tax Code. And for that, I have the case of Haynes, Haynes versus Gay, 2018 Tex App Lexus 1129. It's a Dallas Court of Appeals case that applies 171-255 to limited liability companies. If you could scroll down to head note number 3 in the body of the case, Ms. Daniel. Yeah, in the body of the case. Well, yeah, that's, if a limited liability company's charter is forfeited for failure to pay or report a tax or penalty, the member is liable for each debt the corporation has created and occurred in the state after the date on which the tax penalty is due or before the corporate privileges are revived. In this particular case, the corporate privileges were canceled in January of 2017 as shown by the certified copies, and the debt was incurred in December of 2017, or January of 2018. So we believe that we are entitled to a judgment against Best-Tex Construction LLC and Roy Faruska DBA Best-Tex Construction for $27,279 plus prejudgment interest and the attorney's fees that are in the affidavit and that we have testified to. With regard, we've gone through this, but with regard to the mechanics lien, if the court will review the live pleadings that I went through at the beginning of the case, the court will note that there's been no specific denial that the lien itself, that all conditions preceding to the enforceability of the lien itself have occurred. No specific denial that any particular notice wasn't sent, no specific denial that the lien affidavit wasn't filed timely. The evidence is clear that there is, according to Mr. Faruska, the Big D money was not paid to him by Arturo Hernandez. The lien affidavit of Mr. Faruska shows, or Best-Tex shows, that there is still $35,000 owed. He filed his lien for $35,000. He testified that that money for Big D was not paid. There is an email in evidence where he tells Faruska, go ahead and pay Big D this money. So under the trap funds of 53.083 of the Texas Property Code, we have demonstrated that prior to the payment of the money for the concrete by Mr. Hernandez to Mr. Faruska, we notified Mr. Hernandez at his address at 2467 or 68 County Road 377 with the fund trapping language that's required by the Texas Property Code, that unless the claim is paid or settled, he's not to, his property will be subject to a lien unless the claim is paid or settled. He then has the duty to hold that money, and when the contractor, Mr. Faruska, consents to the payment of it, the property code says that Mr. Hernandez is to pay it to Big D Concrete. Not only that, but he says that in that email that's in evidence. So we believe that we have got a trap funds claim against Mr. Hernandez for the $27,279, that the lien has been properly filed, secured. There's no specific denial of our lien conditions by Mr. Hernandez, just a general denial. And so he has an equitable interest in the property. Both he and Ms. Ma agree to that. The lien would, at a minimum, attach to that equitable interest and any after acquired title, as the Supreme Court said in the diversified holdings, diversified mortgage investors versus Lloyd Blaylock case. And with regard to Alice Ma, I've made my argument with regard to that. I believe that there is reason to believe whether or not whether or not Ms. Ma or Ms. Hernandez, Mr. Hernandez are going to admit these things, having the same attorney, there is reason for the court to be skeptical about what their deal is beyond what they've admitted. Both of them admitted today that when he pays all those payments, he owns the property and the lien attaches to that at a minimum. Thank you. Plus our attorney's fees, please.
May I go first, Greg?
Go right ahead, sir.
I'll be very brief. Thank you, Judge. I'm sort of taking a back seat here for a while. Judge, it's taken 2.5 days for us to figure out sort of what's going on here between Hernandez and Mall, when really we could have probably saved the court a lot of time if we'd have known that this lease has been signed up front, because I think that it changes the whole trial once we determine Ma owns the property. Judge, you yourself yesterday said, who owns this property? And honestly, I don't think any one of us knew at that time. But she does own the property. And today she testified she is the landlord. He is the tenant. The tenant has an equitable interest in the property. How much? I would argue to the court is close to $650,000. He's got it appraised at $850,000. The real estate was $140,000. So Ma actually has everything in the world to gain here as owner. The policy behind this case is, which is really beautiful, if every tenant wanted to do improvements on property and they didn't want to pay, they don't pay, and they line up with the landlord and say, we're going to be on the same side. I'm going to say, you're the owner, and you're going to say, I didn't authorize the improvement. And we're going to walk out of there as a matter of law, not having to pay the vendors. That's the policy that's being argued here. And actually, it's wrong. It's a landlord-tenant relationship. The tenant under the contract has a right to make improvements, which he did, to the tune of $650,000. The land was lien. You go to paragraph 17. He was supposed to either pay the lien or object to the lien, which he did not do. So if this case gets even more interesting, because actually he's on default, the tenant is, under the lease. She could actually try to hold him under default, right? And go get the land with the beautiful house on it because he violated section 17. And so I think we have to look to the lease as much as anything in this case, because a landlord-tenant relationship is an agency relationship. And I would even argue that it's even stronger than an agency relationship. It's a real estate ownership under the property code. The tenant has equitable interest here. The court can attach, forfeit the lien, and forfeit his equitable interest in the real estate, as well as the landlord's interest. I think they waived any argument on the legality of the lien. They didn't file any affirmative defenses as far as illegality of the lien, improper notice, payment, contributory negligence. None of that was affirmatively pled by either one, Ma or Hernandez. So I would argue that defense is waived. I would also just ask the court to find that the lien is legal. The landlord-tenant relationship simplifies this case, Judge. You asked the perfect question yesterday. Who owns this property? Ma owns the property. And the lien is legal. Both Hernandez and Ma have testified that they've received the lien. They've been put on notice. Neither one of them has filed any, which they testified to, which they have not filed any motion to discharge the lien or remove the lien, dismiss the lien. I think they waived any argument on the legality of the lien. It's just a matter of the judge finding that Ma is the owner and he is a tenant and he has the equitable interest and she has the ownership interest. And the court might be sitting there thinking, well, Brett, she didn't really contract with him. Yeah, but she did when she did the lease. She gave him the right to make improvements. She can't sit there in silence going, well, I didn't know he did that. When in the lease, she gave him a right to do it, right? And so she benefits greatly if he quits paying her rent. If he quits paying the $3,800 a month, she defaults, she gets $800,000 property that she only has $140,000 in. It's a brilliant defense. That's the reason I was arguing yesterday, conflict. I didn't want to chase it down, but it's a brilliant defense. The policy doesn't hold up. It's a lot simpler case than what we've been arguing when we found out Ma was the owner and that there is a landlord-tenant relationship. Thank you, Judge.
May it please the court. Your Honor, we've hearing from Mr. Stahlcup and Mr. Mallers a great amount of equitable arguments, which are totally in opposite to the claims against my clients. Lien law is not equity. It's a matter of statute. So the equitable arguments can and should be ignored. They just don't apply here. Mr. Stahlcup stated several times that there was no way to know who owns the land until today or yesterday, unless you go to either the Collin County Central Appraisal District site, which is public, or you go to the Collin County records site, which is also public. Or if you look at the pleadings or discovery in the case. Any of those three ways would be a way for Mr. Stahlcup to know who owns the property before today. Ms. Mott did file numerous verified denials. That's not an issue. I won't bore the court going through the Best-Tex case again, but I believe if the court will look at the requirements for ownership, the requirements for apparent authority, actual authority, express authority, every other kind of authority, the testimony does not get big D there. Thank you, Your Honor.
Judge, can I just respond for 30 seconds? Paragraph 16 of the lease prevents the tenant from making any alterations or additions to the property without the landlord's written consent. I mean, all the statements with regard to how he didn't need her consent to do things, and he could just build a house without her consent, without her knowledge. It's contradicted by this document that was the only thing produced, and it's my understanding the only thing that counsel has. And it seems to me like these protestations that, well, we didn't know this or we didn't know that, are flatly contradicted by the documents that are in evidence.
Okay.
Your Honor, 30 seconds. 30 seconds.
Briefly.
Mr. Mallers sounds like he's representing Alice Ma here in a case against Mr. Hernandez. He's not. Thank you, Your Honor.
Okay, thank you. Okay, the court would like to review the Best-Tex case, and I also would like all three of the lawyers to submit their proposed orders. If you will email those to Ms. Pierce, make sure it's in a Word document so I can revise those and I will get you a ruling.
Your Honor, I missed the very first thing that you said before drafting of orders.
To email a copy of the Best-Tex.
Yes, Your Honor.
All right, thank you.